Hello, everybody.
Clayton Dubois, cause number 4A0691045. On for an arraignment. Is Mr. Dubois in the courtroom?
He's getting here, Your Honor.
Great. Thank you so much, Deputy. Do you have the PC on this one, Mr. Kilpaw? I didn't see it.
I do, Your Honor.
I don't think I actually saw PC on any of the add-ons today. I don't have Corporal Rubius or Johnny either.
I thought I sent them all to the court the first thing this morning, but I hand them forward as need be, Your Honor.
Okay. Morning, Mr. Dubois. I'm going to be just a moment, sir. I need to review the probable cause statement. I'll be right back with you. Okay. No comments on PC, you said, counsel?
No.
Nothing on it. Court does find probable cause is established for the charge of driving under the influence. Is defense ready on arraignment?
Yes, Your Honor. At this time, we are prepared to waive a formal reading of those, waive a formal reading of rights, and enter a not guilty plea on his behalf.
All right, Mr. Dubois, I'm going to go ahead and waive a formal reading at counsel's request. This is just as to the driving under the influence charge. I'm entering a not guilty plea on your behalf, which does preserve all of your rights towards that charge. Would the city like to be heard on release conditions?
Yes, Your Honor. Your Honor, I can just tell the court right now that this case is related to another investigation. The defendant is currently being held on an attempted murder in the second degree. At this time, based on the facts that we have here, the city would ask for $10,000 cash court for performance bond. We would also be asking for pre-trial monitoring with random UAs as well, should the defendant post bail and be out of custody. It was alleged that there was alcohol, drugs, a mix of a lot of different things, Your Honor. So I do believe that pre-trial monitoring would be the appropriate remedy here in this situation at this time. I can tell the court that this was an add-on yesterday, just to look at his Washington history. I'm not seeing any other history pop up, as well as in our long arm database. Not seeing anything else, but I'm surprised I'm not seeing that murder in the second degree, which makes me wonder if Jabs isn't pulling up all of the defendant's history. So I don't know if the court has any other information at this time, but based upon the probable cause statement, I believe that the city's request is justified.
So I just want to make sure I'm not missing anything. As far as the DUI PC I read, I didn't see anything in relation to the attempted murder. Is it directly related to this?
Your Honor, my understanding is that there was a pursuit, and that this is ultimately where law enforcement caught up with the defendant.
Okay. All right, Mr. Lockhart, what's defense position here today?
And, Your Honor, with no prior history here, we're just asking, it sounds like there's no bail out on the other matter. I don't know if PC's been found on that one or not. We would just ask the court to take into consideration that Mr. Dubois has been in Whatcom County his life long. Due to these charges, he has lost his employment. He does own a home here, however, and that he does not receive any benefits. So certainly could be, based on income here, with the very recent loss of that, it sounds like he might be eligible for a public defender, and certainly not in a position to be able to post any bail. And certainly, depending on what happens in Superior Court, that's ultimately going to change quite a significant amount here. At this time, we're just asking for, perhaps a very low nominal, about maybe $25, something like that, just to have him earn credit while he's there, and certainly something that's not going to keep him if PC is not found on the other matters.
All right. Well, the court has to be very clear on this. The charge, attempted murder in the second degree, is not before this court today. I'm not considering that. I'm not making any rulings. I have no authority to make any rulings in regard to that. That will have to be before a Superior Court judge. What I have here is a first lifetime DUI being alleged, as far as the court understands. I have some concern here. Certainly we had allegations of elude, and fairly significant allegations of substance use. We had allegations of methamphetamines, marijuana, alcohol, all combined. Obviously very, very serious.
Your Honor, I do have an additional report that I was able to find. I've previously been sworn, if I can provide that information to the court as well.
Sure.
Your Honor, I'm reading from Officer Pina's report dated August 20th of 2024. At approximately 03:40 hours, I responded to St. Joseph's Hospital after A hospital security officer called 911, reported that an intoxicated male dropped off a bloody female at the emergency room for treatment. He was trying to drive away. The security staff was trying to prevent him from leaving. Multiple officers responded to the hospital, where security staff was actively wrestling with that male in the drive-through area just outside the emergency department. I arrived on the scene and observed a shirtless Clayton DuBois struggling against multiple security officers with St. Joseph Hospital staff. At this point, I was aware that this man dropped off an injured female and he was not free to leave while this incident was investigated. I also knew that he was suspected of being under the influence and had been attempting to get back into his vehicle. Based on that knowledge, I believe that some force might be appropriate to detain the suspect for further investigation to prevent him from possibly driving away.
Okay. So I still think to some degree what the court was saying stands. This is a DUI allegation. Superior Court will deal with the attempted murder charge. That has nothing to do with what this case indicates, the conduct that's before the court. The court is going to find clearly there's a nexus between substance use, the allegations here, pretrial supervision in this unusual case is more than warranted. I'm going to order the pretrial supervision with testing, random urinalysis. As far as bail, I can't justify $10,000 bail on this. This is not a murder charge. If Superior Court wants to impose significant bail on that, they can impose significant bail on that. I'm going to set it at $1,000 on this. It is rare to set bail even at $1,000 on a first alleged DUI, but I think that the overall circumstances here are unique and do warrant some bail being ordered. So the court does make a finding. I think there is a risk of a violent offense being committed. In this case, that's vehicular assault, vehicular homicide. I'm not considering the murder charge in relation to this. So $1,000 will be ordered. Pretrial supervision will be ordered, and the other charge in Superior Court will have to carry its own weight. So, Mr. Dubois, here to appear timely for any scheduled court hearings, have no new criminal law violations, do not drive without a valid license and proof of insurance, have no drug or alcohol related infractions, do not use or possess alcohol, non-prescribed drugs, or marijuana, don't enter any establishment whose primary business is the selling or serving of alcoholic beverages or marijuana. You will be subject to random urinalysis at probation's discretion. You would have to report to the District Court Probation Department for monitoring with those conditions. They are located on the 4th floor of the county courthouse. That is the building directly next to the jail. Do you know which building I am talking about, sir?
I think so.
All right, that's where you'll have to go if you post the bail here and are released on your Superior Court matter. Again, I can't address that for you. I'm going to set 2 court dates. One will be in custody, one will be out. The in custody date, probably go to 9. Do we want to do 9/4 or do we want to go into the next week?
I'll defer to the court.
Your Honor, the city's preference would be to go to 9/6. This would be Ms. McBrain's case. Just so we don't overload that 9/4 calendar. If the Wednesday in custodies have been, add-on in custodies have been setting any precedent, it looks like we'll probably have quite a few for that date.
I'm just worried that that Friday is also going to get super overloaded with it being a short week, and we know we have less time on Fridays.
We said to the following Monday
Let's do
afterwards.
9/9. So Monday the 9th, 8:30. Out of custody was it 10/21? You said for non-DV. Okay, out of custody October 21st. And I see my clerk found what appears to be other history here, so I'm curious. Okay. In regard to the court's findings here, there is a prior elude conviction. There was essentially allegations, I know it hasn't been charged, but of the defendant essentially trying to leave elude here as well. The court adds on to the findings. It does find that there's also a flight risk here. I'm not going to raise the bail, but I think that's an additional basis why I'm imposing $1,000 here on a first offense DUI. So that's going to be part of the record here as well. Out of custody court date 10/21/24, 1:30 in the afternoon. I'm finding Mr. Dubois eligible for the public defender based on what counsel has said here today. All right, I'm going to go ahead and sign off on this order. Mr. Dubois, do you have any questions, sir?
That I can ask.
Sure. Mr. Dubois, I do have one question for you, sir. Is your last name 2 different words? Is it D-U, then B-O-I-S, or is it all one word?
It's usually just one word.
One word? Okay. So that's how you found the other history. Okay. So the court's going to go ahead and correct that. Counsel, would either party like to be heard? My clerk just uploaded an order on motion simply correcting the last name to mean Dubois as one word.
The city has no objection and would ask the court to change it and combine the history.
All right, we're going to go ahead and enter that. Okay, signing off on that, Mr. Dubois. Thank you very much for your patience today, sir. Your hearing is concluded.
All right.
I expect you'll see a Superior Court judge later.
Your Honor, Mr. Warmbrough.
Brock? Yes, sir. Oh, I'm sorry.
Okay, we're starting our informal first appearances for Monday, August 26th. State appears by Assistant County Attorney Ms. Plashka. We're going to begin with State of Kansas versus Cody Scott Warmbrough, case number MGI 21 CR 537. Mr. Warmbrough appears in custody by Zoom, having been arrested on 2 arrest warrants. One issued by me, that is in case number 21 CR 537, and then one issued by Judge Collins, that being case number MGI 24 CR 234. But both these cases are assigned to Judge Gossard. And Mr. Warmbrough, in case number 21 CR 537, I'm going to give you the abbreviated version of what you're charged with, as you're charged with 13 counts. Count 1 is flee or attempt to elude law enforcement with 5 or more moving violations. That is a level 9 person felony, carries a penalty of 5 to 17 months in prison, a fine up to $100,000, and 12 months post-release supervision. Count 2 is improper turn or approach. That is a traffic infraction, typically punishable by a fine. Count 3 is failure to yield a stop sign or yield sign. That is a traffic infraction, typically punished by a standard fine of $75. Count 4 is speeding. Excuse me, that's a traffic infraction, punished by a fine per schedule, depending on the speed you're traveling. Count 5 is improper passing. That's a traffic infraction, also punishable by statute, which is a fine or is a Class C misdemeanor. Count 6 is improper driving on a laned roadway. That's also a traffic infraction, punishable by a fine or is a Class C misdemeanor. Count 7 is driving while suspended, second or subsequent offense. That is a Class A non-person misdemeanor. Here's a possible penalty of a minimum of 5 days, up to 1 year in the county jail, not eligible for parole until after 5 days in jail has been served, and a fine of at least $100 up to $2,500. Count 8 is reckless driving, first offense. That's an unclassified misdemeanor, carrying a penalty of up to 1 month in the county jail and or a fine up to $500. Count 9 is failure to yield at a stop sign or yield sign. And also counts 10 and 11. And those are all traffic infractions, typically punished by a fine of $75. Count 12 is improper turn or approach. Infraction, typically punished by a fine. And count 13 is also improper turn or approach, a traffic infraction, typically punished by a fine. Each of those 13 counts are alleged to have occurred on or about June 16, 2021 in Montgomery County, Kansas. You understand your charges in that case, Mr. Warmbrough?
Yes, sir.
All right. In case number 24 CR 234, we're charged with 4 counts. Count 1 is flee or attempt to elude law enforcement during a police pursuit. That is a level 9 person felony, carries a penalty of 5 to 17 months in prison, a fine up to $100,000, and 12 months post-release supervision. And count 2 is driving while suspended, second offense. That's a Class A misdemeanor, carries a penalty of up to 12 months in the county jail, must serve at least 90 days confinement, and a fine of not less than $100. Count 3 is failure to obey traffic control device. That is an infraction, carrying a penalty of a fine not exceeding $500. And count 4 is unsafe turn, fail to signal. That is an infraction, typically punished by a fine not exceeding $500. And those 4 counts, in this case, are alleged to have occurred on or about July 13th of this year in Montgomery County, Kansas. You understand your charges in that case, Mr. Warmbrough?
Yes, sir.
Excellent. When you're not in jail, Mr. Warmbrough, where are you residing?
It's in Coffeyville.
In Coffeyville? Okay, how long
Yeah,
do you live there?
About 3 years.
Are you employed?
Yes, sir. I work at through Temp Express, making $21 an hour. I work as a certified welder. I'm 5 years clean now, sir. I got a baby on the way. Like my wife is 8.5 months pregnant. She's about to pop. I'm the only one with a job in our household, and I'm hoping you might let me out. And I'll make sure, just like you did last time, I'll be here at court every time. I'll supervision all of it.
Okay. Now you work temp through Express for what company? Who are you
Uh,
welding?
TCL over at Neody Shea.
Okay. Now refresh my recollection, Mr. Warmbrough, on your criminal history. What kind of prior convictions do you have on your record?
Like 2 counts of aggravated, like 7, 8, 9 years ago.
Of ag battery?
Robbery. I
Robbery?
went to prison, served my time and all that for it, and haven't really been in trouble since.
Okay. What causes me concern, Mr. Warmbrough, is in both these cases, both the 21 and in the most recent 24 case that allegedly occurred just a month and a half ago, you are alleged to have fled law enforcement. So that causes this court some concern. Ms. Plashka, what is the state's bond recommendation? I do note that on the 21 case, for which I signed and put a bond amount on, but of course that was 3 years ago. That was 5,000 cash surety of supervision. That doesn't account for the new case. What's the state's bond recommendation to cover both these matters?
State would request a $5,000 cash surety bond with supervision, Your Honor. State is concerned that both of these involve the fleeing and looting and also driving while suspended. So state would inquire if the court could admonish the defendant to not be driving while he's on bond.
My wife takes me everywhere, ma'am. Thank you so much.
Except for these two alleged dates in which you were driving.
And may I speak, Your Honor?
Not about these cases, Mr. Warmbrough. If you have something else to say, you can.
Never mind. I appreciate it. Thank you.
All right, Mr. Warmbrough, I'm going to have your bond be the $5,000 cash or professional surety of supervision that I set in the 21 case. That'll cover both cases, though. So to get out of jail, you either have to post $5,000 to the clerk of the court, or you can go through a bondsman. If you go through a bondsman, you typically pay them 10%. It wouldn't be any less than that. But that's between you and them, so that'd be $500. The supervision component means that the very first stop that you would make when you got out of jail is to our court service office in Coffeyville. That's where you live,
Okay.
correct?
Yes, sir.
So you would immediately go to the 3rd floor of the Coffeyville courthouse.
Can you write that down for me?
When you get out of jail, you'll check in with them. They'll give you some times to report. Typically, it's once a week on a Wednesday between 8 and noon. Sometimes they have you do it by phone. Sometimes they want you to do it in person. But you need to follow their orders, the same as if I ordered you to do it. Any questions about that?
No, sir. I really appreciate it. Thank you so much.
If you were to fail to report to them upon your release from jail or any time thereafter, that would be a violation of your bond, and that could result in you finding yourself back in custody. And I would remind you that if your driving privileges are in fact suspended, you are not to be driving.
Yes, sir.
As a reminder. So you need to check in with court services. Your next court date, as these are assigned to Judge Gossard, is going to be September the 12th. That is a Thursday. That'll be in person at 9 o'clock here in Independence. So you'll go
Okay.
upstairs to the building you're in now by 9 o'clock on Thursday, September 12th. Now, do you plan on hiring your own attorney? Do you want the court to consider appointing you one?
I would like the court to send an appointment one. I had Gary House last time.
All right, well, the court will give you, or the deputy will give you an application and an affidavit. Get that
Okay.
paper filled out, return it. If you qualify financially, it will appoint an attorney for you. We'll have to look at your situation to see if you qualify. If you don't qualify, you'll have to attempt to hire your own. Any questions about
Right.
that?
No, sir.
All right, so the sooner you get that return, the sooner we can make that determination. And you might have an attorney appear with you on the 12th of September if you return that timely and you qualify.
All righty.
That will be an attorney review hearing. Any questions, Mr. Warmbrough?
No, sir.
Anything from the state, Ms. Plashka?
No, Your Honor.
All right, that's all for today. Thank you, sir.
Thank you.
Be safe, be well, sleep sweet, and much love.